know, I'm Vera Scanlon. I'm a federal magistrate judge in Brooklyn. In my job, I work with the United States Constitution every day. So today, I plan to give you a short overview of the process by which the United States Constitution was created and ratified. It was ratified in 1787, and September 17th is the date that we celebrate that event. So what is a constitution? The Constitution of the United States of America is the supreme law of the land. It's the source of all government powers, and it also provides important limitations on the government so as to protect the fundamental rights of our citizens. When the United States first became a nation, the structure of the national government was written down in the Articles of Confederation. But after a few years, it became clear that a more centralized government was needed. So Alexander Hamilton, who I'm sure you've all heard of because of the musical Hamilton, called for a meeting of representatives. Those representatives came together in the Constitutional Convention, which was held in 1787 in Philadelphia, Pennsylvania. Representatives of 12 states went to Philadelphia that hot summer in 1787 to participate in the Constitutional Convention. There was much discussion of what this new government should be like. Some of the most important drafts were the Virginia Plan and the New Jersey Plan. In the Virginia Plan, there would be a two-house legislature and a very strong executive. In the New Jersey Plan, there would be a one-house legislature in which each state would have one vote in Congress. Together, the members of the Constitutional Convention came to a compromise, and they decided that the Senate would have 2 votes per state, and the House would have votes based on population. Together, they formed the United States Congress. The convention finished its work in 1787, when 38 of the delegates in attendance signed the United States Constitution on September 17th, 1787. That's why we celebrate that date, September 17th, as Constitution and Citizenship Day. Can you imagine all that work? Of course you'd say, finished.
Congress privately reviewed and debated the proposed Constitution. On September 28, 1787, Congress, in these words, sent the Constitution to the states for consideration and ratification. Congress, having received the report of the convention lately assembled in Philadelphia, resolved unanimously that the said report, with the resolutions and letter accompanying the same, be transmitted to the several legislatures in order to be submitted to a convention of delegates, chosen in each state by the people thereof, in conformity to the resolves of the convention made and provided in that case.
The Constitution's first words are very, very famous. I'm sure you've heard the phrase, "we the people." Those words follow with this. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Ratification followed over the next several years. Under Article 7 of the proposed Constitution, the Constitution would not become the official governing document of the United States until at least 9 of the 13 states ratified the new Constitution. Slowly but surely, the states ratified the Constitution in the following order. Delaware was first, followed by Pennsylvania, New Jersey, Georgia, Connecticut, Massachusetts, Maryland, South Carolina, and New Hampshire. When New Hampshire ratified the Constitution, it became the governing document of the United States. But you might be able to guess there are two very important states missing from that list, and effectively, the Constitution was not really the governing document of the United States until they signed on. Can you guess what states are missing? A hint? Virginia came next, and then New York. Once they had signed on, the Constitution really was effectively the governing document of the United States. Following their example came North Carolina, and after that, Rhode Island. The Congress under the Constitution first convened in New York in March 1789, and George Washington was sworn in as the President of the United States in April 1789. But the Constitution did not include provisions for protecting individual rights or limiting the power of the federal government. So in 1789, James Madison introduced the Bill of Rights to the House of Representatives of the United States Congress. And by 1791, 10 of the 12 amendments that he had proposed had become the Bill of Rights. I'm going to briefly go over what was included in the Bill of Rights, and later in our presentation, you will learn in some detail some of those amendments. The one you might know the best is the First Amendment. It protects rights of religion, speech, press, assembly, and petitioning the government. The Second Amendment protects the rights of citizens to bear arms, and the Third Amendment protects the rights of citizens against quartering troops. The Fourth Amendment protects citizens against the right against search and seizure. And the Fifth Amendment covers many rights, all of which are related to criminal justice, as well as private property. The Sixth Amendment protects rights at trial. The Seventh Amendment protects the right of a jury. The Eighth Amendment protects against certain conditions under bail and cruel and unusual punishment. The Ninth and 10th Amendments relate to the structure of government and the people's relationship to the government. Under the Ninth Amendment, the focus is on the people retaining their rights not included in the powers of the government. And under the 10th Amendment, the states and the people retain certain rights. That's the end of the Bill of Rights, but not the end of the amendments to the United States Constitution. There have been many more, including the most recent, which was passed in 1992. Some of the ones that you may know very well are those related to the events following the Civil War. Those include the 13th, 14th, and 15th Amendments. And this year, we're celebrating the 100th anniversary of the 19th Amendment, which ratified the women's right to vote. There have been many changes to our Constitution. It's been improved over the years. So the question for you, as a student of civics, is if we were to have another constitutional convention, what constitutional amendment would you propose today? We hope that gives you a lot of information to think about the United States history and civics and what your contribution to our country might be. Thank you for joining us, and thank you for celebrating Constitution and Citizenship Day.
My name is Stephen Locke, and I am a United States Magistrate Judge in the United States District Court for the Eastern District of New York. And my job today is to speak with you a little bit about the First Amendment to the United States Constitution. But before we get into that, I want to explore a little bit of the background that I think you need to know in order to have a better understanding of what I want to tell you about the First Amendment. Now, by now, you may have heard from Judge Bianco about the courts and Judge Tomlinson about the Sixth Amendment and juries, but I want to give you sort of a big picture view so that we can talk about where the Constitution fits in to our government, and then where the First Amendment fits within the Constitution. Okay, now as you probably know, on July 4th, 1776, and yeah, I'm going back a ways, the United States declared its independence from the King of England, right? And there were a lot of reasons for this, but one of the main reasons was that the colonists were tired of being ruled by someone who didn't answer to them. They didn't have a representative form of government. Now, when a new nation is born, as you can imagine, there's a lot of work to be done, right? And the first thing you need to do, of course, is to get everybody to recognize you as a new country rather than as a colony of another country. And frequently, and what happened with the United States is it took a war, right? It took the American Revolution. But once you declare independence, then what? You got to keep things running, right? And so you got to decide what you need from your country. You might need an army or a navy for protection. You might need a post office, right, to keep correspondence going. You have to remember that when this country started in the 1700s, there was no email, there was no text, there was no internet, right? So if you wanted to correspond or do business with somebody that was too far away to walk, you would need something like a postal service. And so all of this had to be thought about. And then once you realize that you're going to have a variety of needs as a country, you got to set up something to maintain the apparatus, the mechanism. And this is going to be your government. And so from that, you need to start somewhere, right? So you have to think about, well, who's going to run the government? Who are we, the people, going to give the power to? And how are those people we give the power to going to be responsible to us? How are they going to represent us? And here in the United States, the first document that was adopted to create the framework for that federal government was our Constitution, right? The Constitution is our foundational document as a federal government. It's the cornerstone. It's the document from which all of the federal government's power derives. In the late 1700s, while the ink was still wet on the original Constitution, the people who created it recognized that this country is going to change. It's going to evolve, and the government's going to need to change and evolve with it if it's going to survive. So from the very beginning, we had the Constitution, and we initially added 10 amendments. Okay, one prominent example of how this is so important and why the Constitution needs to be this evolving document is that you have to remember slavery was legal in this country when the Constitution was adopted, right? And for almost another 100 years, it was legal. It wasn't until we had constitutional amendments in the wake of the Civil War that it became illegal. For the rest of our conversation, we're going to talk just about the first of the 27 amendments, right? Just the first one. And I promise you, the first one is big. It's a whopper, right? And you could argue or suggest if we had only one amendment, if only one change was necessary, this would be the one. It's that important, right? And there are people whose job it is just to study the First Amendment. And if you go to law school, you may study with some of them. Or if you go to court, you may work with some of them. Their entire job is to work with this amendment. All right, so here we go. Let's get down to it. This is the meat of what I want to talk about. The First Amendment says, and it's a little bit long and it's a little bit choppy, but it's important because it's so action-packed, right? It's a big deal. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for redress of grievances. That's a lot. That's a mouthful and covers a whole lot of ground. Okay. So if we were to summarize just the First Amendment, not what it means, but the language itself from a very high level, some people call it the 5 freedoms, right? What it provides for is the freedom of religion, the freedom of the press, freedom of speech, the freedom of assembly, and the freedom to petition the government, right? Now, there's no way I could possibly cover all of this in the next 15 minutes that I've been allotted. So I'm going to talk about 2 of them. We're going to talk about the freedom of religion, We're going to talk about the freedom of speech. And the reason I want to focus on these two is because, as we're going to see in a minute, these two have real and immediate implications for you as students. Now, I realize as a student, your job is to study, learn something, get a good grade on the test, which I'm sure you will on this test, and then you move on, right? And it's hard to remember everything and keep it all in you as you continue to go through school. The First Amendment is a little different, right? Because a lot of times you learn things, you learn about earth science, and then you forget about earth science and you move on to chemistry, right? And it's different, and you may not need all of one to get to the other. The First Amendment has real implications for you as students, not as future adults, not as future members of the workforce or paying taxpayers, as students in your classrooms studying. This has real ramifications for you. You have constitutional rights, and that's what we're going to talk about right now. Okay, we're going to talk about first the freedom of religion. And you may remember from a moment ago, there are really two components to that part of the First Amendment, right? Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof. Those two clauses are commonly referred to as the Establishment Clause and the Free Exercise Clause. And these provisions make some sense if you think about the Constitution in terms of history, right? The first European settlers who came here belonged to religious groups that were persecuted in their home countries, and they wanted to be free to worship as they pleased. I grew up in a small city north of Manhattan called New Rochelle, and it was founded by a group called the Huguenots. The Huguenots lived in France in a place called La Rochelle, that's New Rochelle, and the French king wanted them to drop their religion and join the Catholic Church. They didn't like the idea of that. So they got on a ship, headed across the Atlantic. Years later, still in the 1600s, New Rochelle was formed, right? They wanted to go their own way and worship as they pleased. Now, the first of the two clauses we talked about, it will be the Free Exercise Clause. And it allows citizens like you and me to attend houses of worship where we want and worship as we please without government interference, right? The key to the First Amendment and the Constitution is that limitations are on government action, government interference. Your parents are free to interfere with how you do things however they want. The Constitution doesn't apply to that, right? This is about what the government can do to limit your conduct. Okay. Now we're talking about the Free Exercise Clause, your freedom to worship. The problems that arise typically and then come to court are when a government, maybe a local government, New York City, I work in Long Island, one of the towns in Long Island perhaps, enacts a statute or a law that might interfere with someone's desire to worship as they please. For example, here's one, a law outlawing polygamy. Polygamy is when one person marries more than one other person. Historically, it involved a man having more than one wife, right? Let's say Congress passes a law that says you can't have polygamy. And there probably are some good reasons that you can think of why that might be appropriate. But now let's also say that there's a religion that has one of its core values is that a man will marry as many women as he can so that he can have as many children as he can, right? There might not be anything fundamentally offensive about having a lot of children, but polygamy, is included in that value, right? Congress says can't do that, can't have more than one wife. The way that dispute gets resolved is that the parties come to court and then the judge decides, right? So these parties come to court and the judge would decide, yes, that statute prohibiting polygamy violates the First Amendment Free Exercise Clause, and then so it's no good, right? It's invalid, it's null and void. Sir, you can continue to be married to your 3 wives, or you can't, right? The Free Exercise Clause has limits, the judge might say, and this is one of those limits. You can believe what you want, worship as you please, you cannot have 3 wives. Now, you can imagine that this kind of issue would come up in a lot of different contexts, right? What about religions that require the use of illegal drugs during ceremonies? What about religions that require animal sacrifice, right? during a religious ceremony? What about a religion that says we're only going to send our children to school until age 14, even though local law requires students to go through high school, typically through age 18? What happens there? The judges addressing these questions are required to apply the free exercise clause to decide what's permitted and what's not. Now, back in the polygamy case, what the court reasoned was that, well, the law's not controlling or prohibiting you from exercising your religion, and it's not trying to control what religion you might belong to or what you think. It's just controlling conduct uniformly, right, to all citizens, and that's okay. That doesn't always work out so well depending on the factual context, and I just gave you a few others. But this is hard work, right? This is why we need smart people to become lawyers and work these problems out, right? And so that's what's going on with the free exercise clause. The next part I want to talk about is the establishment clause. And remember, we're still under the umbrella of freedom of religion. The establishment clause was designed to prohibit Congress from creating a national religion. I want to spend a little more time on this one because there's a direct application to you as students. And this is my first illustration of why the First Amendment matters to you, not as citizens, but as students, as people now. It's more than just studying to get an A on this test, right? Now, when I went to school, every day started off with morning announcements, right? You stood up, you might say the Pledge of Allegiance, and then there'd be just a series of statements about what's going on that day. In some schools, at a certain time in history, there was also a daily prayer or perhaps a Bible reading right at the beginning of the day. And the notion was likely to remind students that there might be a higher force than themselves, something greater than themselves. And it's a way to remind students to be considerate of others. And I think there's a logic to that, right? I think there's a valid reason to want to do something like that, to teach that lesson to students. But as you can imagine, there are problems with that, right? And it met some resistance. For example, what if you are not of the religion that the prayer comes from? What if you don't use the same Bible that's being read from? What if you don't use a Bible at all? What if you're not religious? What if your parents are not only not religious, they're anti-religious? They think a lot of harm has been done in the name of religion, more harm than good, in fact. Now, here, I want to remind you that when we're talking about schools and parent schools, I'm only talking about public schools, right? Schools that are paid for with taxpayer money and exist pursuant typically to some kind of local law or local regulatory scheme or both. Remember, everybody contributes to that tax base, right? So the parents of religious students pay money in terms of taxes, and so do the parents of non-religious students. And all of this money goes to pay for the teachers and the buses and the school supplies. So you have people with different values, working together to create a school, which is laudable, but at the same time, they're disputing what exactly the education should contain, what should it be comprised of. Should there be prayer in schools? These are real values clashing. And what happened in this case was that ultimately it went to the Supreme Court, and the Supreme Court said, no, you can't have prayer in schools. You as public school students cannot be forced to participate or be present for a prayer in school.
Hello to all of you students and teachers who are joining us for this special program about the birth of our country, and particularly the anniversary of Constitution Day, which is celebrated every year on September 17th. My name is Kathleen Tomlinson. I'm a United States Magistrate Judge, and I welcome you to this part of our program. Next to the Declaration of Independence, the Constitution is the most important document in our history. And why is that? Well, the United States Constitution sets forth the ideals and principles on which our American system of government was founded. And it shows us the vision of our forefathers and what they had imagined founding a country could do in terms of a country being dedicated to the principle that all men and women are created equal. In your classrooms, I know that you've been learning about the three branches of government. You know what they are. I can hear you repeating them. The executive branch, which the president heads, the legislative branch, which involves Congress, and the topic for today, which is the judicial branch. As Americans, we enjoy one of the greatest gifts you can think of. That's the gift of being a citizen of this great country. What's really interesting is how little our country actually asks of us in return for the privilege of citizenship. There are really only 4 things on that list. The first one is to vote in federal, state, and local elections, all of which are so important. Sometimes we take that right for granted. It's just something that we expect as part of life in America. That right was secured by our ancestors who broke away from England and formed the American colonies. It's an extremely important right, one that makes us different from so many other countries around the world. Several days each week in the federal courthouse here in New York, people who have come from other countries to live and work in America take the oath of citizenship to become citizens of the United States. My fellow judges and I administer that oath, and I wish you could see the faces of the new citizens when we do so, because they are incredibly happy to finally become citizens of the United States, something that they've worked so hard for to accomplish over a long period of time. It's not easy, but they treasure the rights that come along with being a citizen. The second thing our country asks of us as citizens is to pay taxes, something nobody likes, but everybody understands why it's necessary. Because the government can't function without money and revenue to build roads, to hire police officers, firemen and women to protect us, to support our armed forces, and that money has to come from somewhere. And your parents and teachers here certainly have been paying taxes for a very long time. The third thing our country asks of us is to serve in the armed forces in time of war, something that we hope and pray never happens. And how blessed we are that we have men and women who volunteered to serve in our armed forces, both here and around the world. So now we have 3 of the 4 things that our country asks of us as good citizens. Can you see the question mark now in that last circle? What's the 4th thing our country asks of us? Think about it. I can see some of you out there with the wheels turning, guessing what it is. If you said serve on a jury, you're absolutely correct. So there you have it. Our diagram is now complete. Isn't it remarkable how little our country asks of us in exchange for the privilege of being citizens? I want to focus now on that last item, serving on a jury. Jury service is such an important part of how our system of government works. Where do you think we Americans came up with this system of jury service? If you said England, you are absolutely correct. You can see this likeness of an old English judge, complete with his wig. And if you've seen any old movies or news that sometimes comes from Great Britain, you'll still see the judges wearing their wigs, along with the lawyers who appear before them. Actually, jury service goes back almost 1,000 years to medieval English law and society. That's a long time. Our jury system is based on principles we inherited from the English system. The idea grew out of the notion that when people are charged with a crime or when they have a civil dispute, they should have those issues resolved by a jury of their peers. People just like them, just like us, people from the community where the parties live and work. Over the past 200 years, that principle has become the foundation for our modern jury system, which looks a bit like this. Usually 12 ordinary citizens who hear the evidence and listen to instructions on the law which the judge gives them, and they come to a verdict based on the facts and in accordance with the law. When we look at the history of juries in America, we start with the Declaration of Independence. Among the list of reasons the founders of our country gave for rebelling against the English king appears right in the middle of the Declaration. It was such an important reason. As you see here, the words directly from the Declaration itself. for depriving us in many cases of the benefits of trial by jury. So you can see how important this matter of trial by jury was to the American colonists. In particular, Thomas Jefferson was very concerned about preserving a jury system in America. As you can see here, Jefferson once wrote that, quote, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution." When America won its independence and wrote its own Constitution, you can see how important juries were to people who founded our country. Right here in Article 3 of our Constitution, the jury was considered an instrumental part of how we govern ourselves. Ordinary citizens, every day, participating in government and carrying out the law. It's so interesting to see this idea again in the Bill of Rights, which you all know now are the first 10 amendments to the Constitution. Nothing in the Bill of Rights was more central at the founding of our country than the jury. The jury is very specifically mentioned in 3 of the 10 amendments. The 5th Amendment talks about grand juries. But then we're here today to talk about the 2 amendments, the 6th and the 7th. The 6th Amendment governs juries in criminal cases and ensures that someone accused of a crime receives a fair and speedy trial. And the 7th Amendment, which then and now today permits jury trials in civil cases. Did you know that when the Constitution was written, women couldn't serve? Look at that jury box. Look at all those men. Only men could serve at the time because men owned property, and that was a requirement to serve as a juror. Thank goodness, as all of you young women out there are breathing a sigh of relief, I'm sure, things have changed. Women now serve on juries equally with men. In fact, this summer, we've just been celebrating the 100th anniversary of the 19th Amendment to the Constitution, which gave all women the right to vote. A great time to celebrate. In order to serve on a jury in our country, you have to meet 3 qualifications, only 3. Can you figure out what those 3 are? First of all, you have to be an American citizen. That means you were either born here or you became a naturalized citizen after you moved here. We talked about naturalization a little bit earlier, and if you're seeing these videos each day, you'll have the chance to see an actual naturalization ceremony as part of this celebration of Constitution Day. So you have to be an American citizen. What's the second factor? Well, you have to be a certain age to serve on a jury. Can you guess what age that is? 18, 21, 25, 30? I can hear some of those guesses out there. If you guessed 18, you are correct. So that means in just a few years, you'll have the opportunity to serve on a jury and fulfill one of the most important responsibilities you have as an American. The third qualification that's necessary to serve on a jury is that you've never been convicted of a serious crime, and we call a serious crime a felony. So there you have it. Those are the 3 things that are necessary to qualify to serve as a juror. Today, juries have to represent a fair cross-section of the community. People from the neighborhoods and communities where the trial is taking place, who come from all walks of life in America. That's what we call a jury of your peers. So we're focusing on 2 types of juries today. The first one, a criminal jury, consists of 12 persons who are called upon to serve in a case where an individual has been charged with a crime. Those individuals are responsible for deciding whether that person is guilty or not guilty. That's different from our second type of trial, a civil jury. Now, in a civil case, you don't have to have 12 jurors serving. You can have as few as 6. Here, you're not deciding The jurors don't decide whether the individual is guilty or not guilty, but rather they determine whether the defendant in the case is liable for the claims brought by the plaintiff and must pay damages to the plaintiff. And that could be a person or company which brought the lawsuit. One of the most common examples here, for example, is when you have an automobile accident and deciding who's responsible. Or we can talk about, for example, a breach of contract case. Not every potential juror is right for every case. The goal here is to select a jury that's fair and impartial. Those are the key words. Fair and impartial in reviewing the evidence that's presented. Lawyers get to challenge some jurors during jury selection, but that's a topic for another day. In that case, if a potential juror is not appropriate for a specific case, then the attorney for either side can challenge that juror, who will likely be excused and another juror selected in his or her place. The jury's role is to determine the facts in a case and to listen to the instructions on the law given by the judge. Jurors have to determine what the facts in the case are and what they believe the facts are. When it's time to deliberate and reach a verdict, every single juror's opinion is equal. No one's opinion is to be given more weight than any other. And the verdict has to be unanimous. In a criminal case, keep in mind the defendant comes with a presumption of innocence. We talk about that presumption of innocence in so many ways. There, the government, the prosecutor, has to prove the defendant's guilt in what we call beyond a reasonable doubt. Beyond a reasonable doubt. That's a very high standard. A civil case is different. The standard of proof in a civil case is what we call a preponderance of the evidence. You have to show that it's more likely than not, meaning greater than 50%, just a mere little tip of the scales in one direction. If that evidence points in favor of the plaintiff, as long as it's over that 50% mark, then you are permitted to reach your verdict in the plaintiff's favor. The juror's role is to listen carefully and exercise your best judgment to reach the right decision. The jury, I think, as you can see now, is vital to our American system of justice. Jury service is a privilege we enjoy as American citizens. Let me tell you what jury service is not. Now, I'm sure this gives you a little bit of a chuckle, and I'm sure you all recognize who this is. Of course, it's Judge Judy. But Judge Judy is a TV show. That's not a real trial. You'll notice that you never see a jury in Judge Judy's courtroom because there is no jury. She decides everything herself, and the parties agree to that ahead of time. This is entertainment. So don't confuse the TV show, which everybody enjoys, but don't confuse that with real life. Jurors are the voice of the people in the justice system. Serving on a jury helps you become engaged in your community in a very special way. It's your civic duty, your duty as a citizen. Jury service teaches us all about what it means to live in a democracy, so important these days. It gives the community the sense that the system works, that the justice system works. And I just want to leave you with some idea of how valuable jury service is here and why it's so important for each and every one of you to become involved in working as a juror and serving as a juror when the time comes. It's very vital to our American system of justice. Without jury trials, people would not get an opportunity to hear their cases heard or to reach a decision. It is, again, one of those four things that we enjoy as a privilege and responsibility when we are American citizens. Jurors are the voice of the people in the justice system. It's not the judge who makes the final determination in a jury trial. It's the jurors who do so. You are the voice of the people. And of course, Serving on a jury is doing your civic duty, and how important that is. Imagine if everybody decided not to do so. The system would fall apart. Now, serving on a jury also teaches us about what it means to live in a democracy. And it gives the community, as I mentioned to you, the sense that the system of justice works. It's my hope that we see many of you here in the courthouses on Long Island serving on a jury in a few years. It's only going to be a few years before you turn 18, so think about that. Remember, this is a precious gift you'll have always by the very fact that you are a citizen of the United States of America. Thank you all for joining us today, and happy Constitution Day.